Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. Today we'll provide another installation into our Anti-Federalist Papers series going on to number 83. So if you haven't gone back and watched 1 through 82, I would highly encourage you to do so because understanding the Anti-Federalist Papers in addition to the Federalist Papers will equip you with a very well-rounded understanding of the U.S. Constitution. And understanding the U.S. Constitution will be absolutely necessary if you intend to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. The version I'm using is provided by the Constitutionalist Society, but there are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers as well. Go ahead and get both formats. While you're out there looking, if you haven't done so already, go ahead and get a copy of the Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 83 is titled The Federal Judiciary and the Issue of Trial by Jury. It's written by Mr. Luther Martin of Maryland. We're definitely going to be reading more of his works. And he has this to say. In all those cases where the general government has jurisdiction in civil questions, the proposed Constitution not only makes no provision for the trial by jury in the first instance, but by its appellate jurisdiction absolutely takes away that inestimable privilege, since it expressly declares the Supreme Court shall have appellate jurisdiction both as to law and fact. Should, therefore, a jury be adopted in the inferior court, it would only be a needless expense, since on an appeal, the determination of that jury, even on questions of fact, however honest and upright, is to be of no possible effect. The Supreme Court is to take up all questions of fact, to examine the evidence relative thereto, to decide upon them in the same manner as if they had never been tried by a jury. Nor is trial by jury secured in criminal cases. It is true that in the first instance, in the inferior court, the trial is to be by jury. In this, and in this only, is the difference between criminal and civil cases. But, sir, the appellate jurisdiction extends, as I have observed, to cases criminal as well as civil. And on the appeal, the court is to decide not only on the law, but on the fact. If, therefore, even in criminal cases, the general government is not satisfied with the verdict of the jury, its officer may remove the prosecution to the Supreme Court, and there the verdict of the jury is to be of no effect, but the judges of this court are to decide upon the fact as well as the law, the same as in civil cases. Thus, sir, jury trials, which have ever been the boast of the English Constitution, which have been by our several state constitutions so cautiously secured to us, jury trials, which have so long been considered the surest barrier against arbitrary power and the palladium of liberty, with the loss of which the loss of our freedom may be dated, are taken away by the proposed form of government, not only in a great variety of questions between individual and individual, but in every case, whether civil or criminal, arising under the laws of the United States or the execution of those laws. That was quite the run-on. It is taken away in those very cases where, of all others, it is most essential for our liberty to have it sacredly guarded and preserved. In every case, whether civil or criminal, between government and its officers on the one part, and the subject or citizen on the other. Nor was this the effect of inattention, nor did it arise from any real difficulty in establishing and securing jury trials by the proposed Constitution if the convention had wished to do so. But the same reason influenced here as in the case of the establishment of the inferior courts. As they could not trust state judges, so would they not confide in state juries. They alleged that the general government and the state governments would always be at variance, that the citizens of the different states would enter into the views and interests of their respective states, and therefore ought not to be trusted in determining causes in which the general government was anyway interested, without giving the general government an opportunity, if it disapproved the verdict of the jury, to appeal, and to have the facts examined into again, and decided upon by its own judges, on whom it was thought a reliance might be had by the general government, they being appointed under its authority. Thus, sir, in consequence of this appellate jurisdiction and its extension to facts as well as to law, every arbitrary act of the general government and every oppression of all that variety of officers appointed under its authority for the collection of taxes, duties, impost, excise, and other purposes must be submitted to by the individual, or must be opposed with little prospect of success and almost a certain prospect of ruin, at least in those cases where the middle and common class of citizens are interested. since to avoid that oppression or to obtain redress, the application must be made to one of the courts of the United States. By good fortune, should this application be in the first instance attended with success, and should damages be recovered equivalent to the injury sustained, an appeal lies to the Supreme Court, in which case the citizen must at once give up his cause, or he must attend to it at the distance, perhaps of more than 1,000 miles from the place of his residence, and must take measures to procure before that court, on the appeal, all the evidence necessary to support his action, which, even if ultimately prosperous, must be attended with a loss of time, a neglect of business, and an expense which will be greater than the original grievance, and to which men in moderate circumstances would be utterly unequal. Excellent. So that is all to be said in number 83. If you have questions about what was said in 83, a very, very short one, go ahead and post those down in the comments. If you have maybe questions about what was said in the preceding papers, or there's a legal topic you'd like me to cover in a future lecture, also post those down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and until I see you all in the next lecture for the next topic, I bid you all farewell.